All right, everybody. Welcome to the Creative Finance Collective. I'm Andy Fowler, and we're bringing in a couple other folks here with us today. We've got Alan Seshker and Sean St. Clair. We're here to talk about creative finance, real estate, and answer any questions that you, the live audience, have. We'll be on as long as we're getting questions. So it's important for you to engage with us with those questions. Because we're busy guys. Alan's got a busy office over in Texas. We don't want to keep him longer than we have to. So if you have those questions, post it. Guys, as we get started, this is, I guess, kind of real estate related if you consider the fact that a lot of investment real estate is owned by entities. I don't know if Sean saw this, but breaking news regarding the Corporate Transparency Act, which we've been following. Sean, have you seen that recent news?
I saw something as of yesterday with some legislation, but that's all I'm aware of.
No, I think so. To this afternoon, the last remaining injunction that was in place. There was one, not the one that went to the Supreme Court, the chop shop one. Is that how you say it? But the last remaining one is gone the same way as the chop shop, following that precedent. So last time I checked, I don't think there's been guidance from FinCEN yet because it's pretty early, but the last remaining injunction that was in place is now gone. And to your point, Sean, I did notice that there has been some federal legislation proposed by Congress to do a couple different things. We'll see if that accelerates, but it sounds like there's not really anything technically until we hear from FinCEN stopping enforcement. What had been some
So
of what you were reviewing in terms of the legislation? What was that?
my understanding, there was a bill that was voted on, I believe yesterday in the House to delay the enforcement until 2026. And that passed the House with a unanimous vote. There was no vote on it. Which leads me to think, well, that's, kind of a done deal, hopefully, in the Senate. I mean, they obviously have to get through the 60-person filibuster threshold, but if
Right.
there's that much, bipartisan support, because they're not saying, at this point, they're not saying that it goes away. They're just saying it's a cluster. Let's delay it, right? I mean, that's
Right.
essentially.
Well,
So
and I
we'll see
understood
what
that.
happens.
Correct me if I'm wrong, but I understood that proposed legislation to apply to businesses formed before 2025 or 2024, something like that.
Before 2024. So anything formed after 2024 would still fall within the, filing requirements.
Yeah. So, well, that's going to be interesting. So you said that in the House it had unanimous support. So
I
in
think
other
there
words,
was a no. I don't think there was one no vote on it in the House.
interesting.
Is
That's hard to imagine that doesn't pass the Senate.
Yeah. Yes.
Did they dissolve the Alabama TRO also?
Yeah,
Alabama never had a TRO. It was only as to those plaintiffs.
So those plaintiffs don't have to comply, but we all do.
Correct.
Well, there's some good conformity in the nation.
Yeah. Boy, if any.
Well, the thing is, the Alabama court didn't issue a TRO. They actually found that the act was unconstitutional in their summary judgment in favor of those plaintiffs.
Yeah. So that case would be on the normal track for the federal government appealing it, basically, right?
Yes.
So
Right. But
yeah.
the judge made clear that it only applied to those plaintiffs.
Yeah. Yeah.
Yeah. So I'm looking at an article right here. It was the Protect Small Businesses from Excessive Paperwork Act. And it was a 408-0 vote to extend the filing deadline out until January 1 of 2026.
Mm.
But to
Okay.
your point, it was only as to entities that existed prior to January 1, 2024.
Right.
And so, wait, if they pat, does it have any information about when it would go into effect?
I believe it will be immediate upon signing by the president because it delays the filing deadline. So,
Okay.
yeah.
Yeah.
So I can't imagine if it was voted, if it had that type of vote in the House that it's going to be really
Yeah.
disputed. I mean, I think it'll go quick in the Senate and then get on the president's desk, hopefully within the next week or two. And FinCEN has already said they're going to provide 30 days. So.
Oh, so FinCEN's already come out?
Well, no, they said in their filing to lift the injunction. So.
I see.
They're going to at least give 30 days.
30 days from when?
From when the court lifts the injunction, which I guess was today. Mm-hmm.
Would be today. Yeah, probably today.
Okay.
Yeah. So, yeah, I'm looking. Apparently, the one bit of legislation that happened in the Senate was what they called the repealing the Big Brother Overreach Act. So that's an attempt to get rid of it in its entirety. That would be a much bigger sell, obviously, to happen quickly than than obviously just delaying it. So.
Yeah, and they won't go for the big thing as long as everyone's protected by the little thing. They'll wait for the little thing to run out.
Yeah, probably. So that's the latest on the Corporate Transparency Act. So it looks like pending some delay, if you haven't done it, well, we're going to know a lot. I would imagine in the next week or two, if Congress is going to work to try to move this thing along, now's the time to do it. So unless the way the dramas has gone on this, we get another court order. But now that we have a Supreme Court precedent on how to treat the injunction, it's really kind of hard to imagine that you're going to get another nationwide injunction given those facts.
Yeah.
All right. Well, if you're just now joining us, we're talking a little bit about the Corporate Transparency Act, but this is the Creative Finance Collective. So we're taking questions that you have about creative finance. So make sure to post those in the chat and we'll get to them. We do have a question from a YouTube listener. I'll pose this to you guys. Pretty simple one, but I think, but worth a discussion. Why not just assume the seller's loan instead of buying sub 2? So why not just a formal legal assumption instead of buying sub 2? And my first thought is it'd be nice if it was that easy, right?
Well, so it's not.
Let's.
I mean,
Alan,
but the only certain loans. Yeah, go ahead, Alan.
Well, I wanted to establish some definitional groundwork because there's confusion sometimes, and so I'm now using that term non-qualified assumption, which means we're assuming without bank involvement. Then we have qualified assumption, which is assuming with the going through the bank process and getting qualified and assuming.
Right.
But
let's assume it's a qualified assumption they're talking about here.
Yeah. And so non-qualified assumption is the equivalent of a sub 2. And then a qualified assumption, it's my understanding that they don't exist too much anymore. We don't see loans that are assumable. Sometimes over in the VA arena, assuming, but the great majority are not assumable. But John, what do you see?
Yeah, I'm going to echo that point. FHA and VA are assumable. FHA, though, is going to generally require an owner occupant assumption. So you're not going to have your investors assuming those loans. VA, I had a client who came to me and we assumed it as an investor on a VA, which was interesting. The assumption is doable. It takes a while on both of those types of loans. You're talking 4 months. I've worked with folks or clients to put leases with purchase contracts in place, so that they could at least get into the property, have it under contract, and work on the assumption while they're in the property. So that is one way to do it if people are more comfortable. It's just, it's a process. There's timeframes involved as far as these lenders and considering things. I mean, you're talking a good 4 months, sometimes up to 6 months before they're going to sign off
And
on
also,
the assumption, but it's doable.
and also qualification requirement. It's the same as qualifying for a mortgage, is my understanding.
Yeah, correct. Yeah, you have to meet the same requirements.
Okay. So Sean, it sounded like you said on a VA, it's taken up as much as 4 to 6 months.
Yeah.
Okay.
And for a VA, you either have to have a veteran take it over, or you have to have a qualifying event that would allow it to be assumed. So, for example, like divorce would be a prime example of an event that would allow you, or you've been job relocation, those types of things are going to allow you to do it. But you can't just wake up one day, no circumstances having been changed, and be like, okay, I'm going to have somebody assume my VA loan, unless it's another veteran, then you can do it.
Right. Now, is with the VA, is the assumption process similar to kind of like the old short sale process where you start with a letter and you got to go through all this, or does the VA basically have a portal where they'll allow for, assumption application and kind of a systemized process?
There's actually loan originators who have the right connections, qualifications, whatever it is, or maybe they just signed up for the program that you work with that will help you get the assumption done, because they're going to be the ones to underwrite the transaction. So you have to find a loan originator that handles VA assumptions.
Is the process on FHA taking longer than VA, or pretty similar? Or have you quarterbacked or
the process on which loan? I'm sorry.
FHA.
It's the same as the VA.
Same.
It's going to be 4 to 6 months, and you need to use a loan originator.
Yeah. Okay. All right. If you're just now joining us, this is the Creative Finance Collective. Make sure to post your questions in the chat. We have another question from a YouTube listener. Are you seeing sub-2 deals on commercial property? No one seems to talk about commercial. Alan, you close a lot of deals. You seen any commercial? We can talk a little bit why or why not, why we see them or don't see them, but are you seeing any?
Yeah. No, we see a lot on the commercial side because bank is involved, and they're usually not too involved like an FHA assumption where they're qualifying buyer and such, but they'll sign off as a release of their due on sale clause if it's even in there, and then we don't see them as much because you don't necessarily need attorney involvement. Docs are going to be drafted potentially by bank attorney. So in the commercial arena, they're
now. Oh, wait, are you talking about assumptions or a sub-2, a straight up sub-2?
Well, so we run into the problem of terminology. A sub-2 is an assumption for me
Yeah.
these days because I draft up a note and deed of trust for a sub two.
Sure.
Therefore, it's an assumption. They're assuming the terms and conditions of that existing loan. So I don't.
I got
I
you.
guess
Gotcha.
strictly speaking, I don't have sub twos anymore. Maybe
Yeah.
because a sub two might just have a deed to secure assumption and no note and deed of trust, which I have. I'm there's an attorney here in Texas that's doing those, and I think it's just incredibly dangerous. The seller has no right of redemption, has no remedy whatsoever. There's not a vendor's lien in the deed, and so when they default, they just have to take it.
So going back to your terminology before, you broke it out into qualified and unqualified assumptions. Is that
Yeah, qualified and non-qualified assumptions.
okay? So then what you were just describing in commercial, is that either or, qualified and unqualified, you're seeing?
Well, it's kind of in the middle because we're not finding the qualification process going on with these buyers the same as a residential assumption, a qualified assumption. It's more the banks involved and they're looking at this thing, but they're not qualifying that end buyer. So I guess it'd be a hybrid, a little middle ground there.
Yeah, what is the bank approving, or what are they even looking at? If
The
they're not,
bank's not approving, but the bank is releasing their due on sale rights.
oh, I see. Okay,
Yeah. So they're coming.
all right. Just out of curiosity, is there a particular type of commercial property you're seeing more of this? Is there a popular space in commercial where you're seeing a lot of this?
No, I've seen both, your retail space and your multifamily residential. Probably more on the single standing structures, businesses, retail centers, stuff like that.
Gotcha. All right. I would think one of the issues you have in commercial is the notes. The loans are not like they are with not your standard 30-year fixed, right?
Right, right. And the banks don't necessarily want the property; they want the payments, and that's why they're fine with that new uh, ob, was obliged borrower. But I guess strictly speaking, they're not their borrower, but they're fine with the second party being obligated to make that payment.
Okay. So it sounds like on the commercial context, they're more hesitant from what you've seen to want to have to deal with foreclosure, and if they can avoid it.
Yeah, if they're a real bank, they don't want defaulting loans and getting properties back.
Do you find that it's harder for for the buyer in the commercial deals to work through, terms given that the interest rates may be higher, the loan terms, are shorter. There's probably balloons on a lot of these, on when they come due.
Yeah, those buyers have their exit strategy already in place.
They've already worked through that. Okay.
Yeah, and if the feds have come and said, "Hey, y'all need to decrease your number, your loans out there," well, then they're not approving it. They're wanting to get that loan finished in some form or fashion. Or if they're warehousing it and it's down there at a lower interest rate, 5, and now they can get 7, 8, 9, they'll make the decision to not allow it.
Got it. All right. If you're just now joining us, we're talking about creative finance. So if you've got questions, make sure to post them in the chat. Alan, as we wait to see if we get any other questions, like to take a temperature and see where things are at. As we're working our way halfway through the first quarter of the year, we've gotten through the change of a new presidential administration. Lots going on there. People are trying to get some sense of where the market's going to be. Seems like there was some slowdown in the creative finance world there towards the end of the year. What are you experiencing kind of in the last 30 days or so? What's it been like in Texas?
So the end of year, December was fine and fast. that could have been attributed to investors wanting the tax benefit of the transaction or what have you. So
Okay.
December was very fast in the investor realm. The conventional or consumer residential was slow, and then January was slow all around, investor and the regular residential. But we've already seen an uptick in contracts, and so we're back to our normal, X number of contracts per day in my little office. So I think everything's back on track, same as last year for us. But again, the investor work is substantially more than the conventional or consumer work.
Sean, what about you? What's been what's been the investor space? Has it been are creative finance deals still happening at the same volume? Have you seen a slowdown, or are there new shiny objects that investors are paying attention to right now?
I don't think there's new shiny objects. I think that I think as rates don't appear to be moving in a downward trend, I think people are kind of waiting for the election to see if that would spur some movement. Obviously, inflation hasn't receded just because Trump's been elected or we have a new administration. And so I'm seeing a trend now where the holdouts, meaning mostly real estate agents, are now thinking, maybe this is a strategy we need to look at, because we're not selling houses. And so I'm seeing that now, where I'm starting to get more consumers, coming to me. I even offer a discounted, assuming I don't have a conflict. If, obviously if the potential buyer is a client of mine as an investor, then I can't do it. But I offer discounted consults for sellers who are thinking about this type of transaction, where I can go over all the, benefits, risks, the whole thing, and break it down for them. And then they can make an educated decision if this is a transaction for them. And so, I think that's a positive to see that. And then I'm seeing even some more consumer buyers wanting to do this transaction this way, because they see the benefits of being able to jump in. And, a lot of times sellers aren't overly greedy, especially when it comes to the interest rate. When they see the number and how much they're going to get a month, it's like, oh, I'll go for that at 5.5%. Well, that's still lower than the market.
Yeah.
So 5.5% isn't outrageous. And so a lot of these sellers, the ones that can do it, I mean, they are like, oh yeah, let's just keep the loans in place. I'll take my 5.5% on the entire loan amount, and the buyer's happy because they're getting a 5.5% in. They can't get that anywhere else. So I'm starting to see that more in the last month, and I think that's a good development.
So that's a fantastic point, because our January numbers, we expect to be below average for January, which is what I was expecting. However, when I looked at the numbers after we were finished, I saw that we were at average, or maybe even a hair above average. I was like, well, dear Lord, that was kind of weird. But the reason was we had three consumer wraps: end user seller, end user buyer, and those are actually usually higher priced or higher value houses, and so they're 1 to 2 million. And because of those three, it clicked us up. Just because our fees on the consumer wraps are pretty high, because like you, Sean, I have a buyer consultation, I have a seller consultation. Sometimes I'll have to have consultation with the mortgage company who's running this thing, and so our fees are substantially higher on those three anyway, without them being a higher priced sale. But that's why, is because of those consumer wraps that I see coming out, and I'm hoping it keeps going that trend. I'm hoping we can normalize this.
I mean,
go ahead, Sean.
Well, to your point, if we can normalize it, I think you're going to start seeing more activity, even greater inventory on the market than what you previously had, because it's just a stalemate at this point where, those with the lower interest rate loans, the golden ticket, they don't want to do anything other than rent their house. But a lot of people don't want to rent their house because it's a pain in the neck to be a landlord. But if you could get money showing up in your mailbox every month, and you don't have to worry about the HOA, you don't have to worry about the pool, you don't have to worry about the landscape, you don't have to worry about the phone calls in the middle of the night from a tenant whose plumbing's gone bad, like the money just shows up. And so and you're still taking advantage of that low interest rate loan.
Yeah. I do think there's something to be said about, I've a number of mortgage brokers that I follow have in the last month recently been talking, excuse me, where they've been seeing an increase in activity. And I think there's something to be said with this idea that a lot of buyers are starting to get used to, interest rates are where they are. We're not going to be able to, they're not just going to suddenly go back to zero, just because Trump's here or whatever else, and just starting to just get used to where we're at, and that it's not really going anywhere anytime soon. Did you guys see, by the way, the real estate numbers for Washington, D.C. recently? So the last report I saw was like the median house price in DC has dropped significantly because of major supply demand, right? There's been a lot of supply. People are moving out. People are losing their jobs. Maybe people had a second home and they're not wanting to come back to the office like they're being required to. But supply has gone through the roof at DC and has really dropped the price of the median property in DC, which maybe will provide interesting opportunities for buyers.
Well, and the smart people that I visit and get to see speak say that the interest rates are set for 25. We're not going to see a substantive decrease. So we do need to settle in. This is our new normal.
Yeah. All right. We do have a comment from a YouTube subscriber here. Let me go ahead and read that if my poor eyes will allow it. This is from Drake on YouTube. I have a real estate agent that's confused on how to get the same outcome of a sub 2 with a wrap, in the sense of having the seller's payment equal the buyer's payment. They continue in another comment. I've never had an agent understand but not understand at the same time. So could you guys help me explain how it's structured in the back end, and what factors make the payments equal as a mirror wrap?
Can I jump in?
Sure.
So it's one of the most frustrating things that we deal with on non-qualified assumptions or sub-twos. What they do is they try to take our Texas Real Estate Commission promulgated forms and start trying to manufacture numbers that equal the numbers of the underlying mortgage. And I'm going to a presentation tonight where I think I've got 3 different slides that tells them the purchase price on an assumption or a sub-two. The purchase price is the non-qualified assumption of the payoff amount of the existing mortgage at time of closing. And that way, as they change daily, payments made, interest accrues, fees are charged, whatever, then your contract changes with it. I call it a word math problem. When you start trying to manufacture those numbers or create those numbers in a seller finance addendum as opposed to an assumption addendum, your contracting is not going to be accurate. And so I try to tell people ignore the numbers, look at them, see what you're going to be paying, et cetera. But your contracting is silent in regard to X dollars. You're saying I'm taking over that, and that's what I'm doing.
Yeah. And your promissory note too, a promissory note can promise performance. It doesn't have to promise a set number. So you can say, I promise to make your mortgage payment each month in the amount of the payment, but you don't have to put an amount in there. There's other ways to phrase it, but you like near existing loan or identical to existing loan or something like that. And that's the language you use. You don't put a dollar amount in. You just say monthly payment amount identical, maturity date identical, principal balance identical to the existing loan. And then, now you have a mere note or a performance note that is promising performance instead of an actual dollar amount.
I guess I'm negligent. I should draft up a really good document that explains that, as opposed to telling them what the purchase price word math problem should be. So I'm going to get something drafted up, and we can start getting that out to everyone.
Good question. Appreciate it. All right, guys. That's all our questions we have today. Appreciate you taking the time, Alan. Before we go, I know, Alan, sometimes you wait till we get on here before you've got something that you've run into that you want to discuss. Anything like that out there?
Well, so I have one. Doesn't apply to you guys because y'all have lease purchase options, but our lease purchase options are limited to 180 days or less. And I had a cute one. It was a lease purchase option, ended up being for 181 days.
Oh.
And so I was on the buyer tenant side. And so I argued, strict compliance with that means that now you're subject to treble damages under Deceptive Trade Practices Act and rescission of contract. And the other attorney said, it's just one day. And so I argued, well, that's a slippery slope. What is it? Is 3 okay? Is 5 okay? 10, 15, 20? So I said, there's a chance that a judge would say, no, 1 day violation puts you under that statute. Now you're, so I was going to ask y'all's legal opinion on that, even though it doesn't apply to all states. Would 1 day bust you?
I would think. I don't know why it wouldn't. Why did they make it 181 days? That just seems like downright intentional or
absolute accidental.
Oh,
Absolute. Wow. They didn't know they were drafting up something that was potentially against the statutes. It was just a builder and a buyer getting the buyer in there early for some reason. I forget why. And so they happened to have a lease simultaneous with a purchase contract. But I think we did the Solomon. We split the baby and everyone went on.
That's probably the best.
That's interesting. When I graduated law school and started practicing, I always thought that these rules and laws were strictly construed and enforced. And then I started practicing and I realized how willy-nilly these courts, view these dates and deadlines and even statutes. Now you have substantial compliance and the whole thing. And you just never know. And they're going to figure out, does a statute, that's the thing is until a court rules on it, you never know if a court's going to say this is a strict compliance statute or a substantial compliance statute. Right. So if it's a substantial compliance, 1 day is not going to kill you. If it's a strict compliance, 1 day and you're hosed and all those damages come into play. So it's, and then, of course, once it's substantial compliance, well, what's substantial mean, right? And that's where your argument is always. So it's, it would be so easy if they just interpreted this stuff as written and enforced it that way, but they don't.
Yeah, you said the two words that my opposing counsel said, substantial compliance, but there's nothing that tells us whether it is a substantial compliance statute or not.
Right.
And then you also described me to a T prior to and going through law school, and then coming out and watching these judges kind of say, close enough.
Right.
It took my beautiful black and white existence and threw gray in there.
Mm-hmm.
See, when I think of substantial versus strict compliance, I think of like a statutory notice that has to go out to somebody, and they say the language that's supposed to be in there, and they'll give a, an example of what that looks like, and yours basically hits it, but maybe not quite. To me, that's different than a straight up deadline. Now, I do agree, tons of courts are going to look past the deadline a lot of times if it's just a day or whatever else, but it's like you either did it or you didn't. Versus, yeah, like again with the substantial compliance, it's like, well, your notice was enough to put them on notice or to do what the statute wanted, so we're gonna, be okay with that. I don't know. That would have been interesting. I think no matter how you look at it, the right result is probably always splitting the baby,
Yeah.
especially if you're able to get there early without spending a ton of fees.
Yeah.
Good. Well, guys, we don't have any other questions. Alan, thank you so much for taking the time to be with us. We appreciate it as always. And let's do it again.
All right. Thank y'all.
All right. Thank you.
All right.
Bye.
See you.